On behalf of the Georgetown Law Institute for Technology, Law and Policy, as well as the Yale Information Society project, it's my great honor to welcome you to the next installment of the AI Governance Virtual Symposium. My name is Nicholas Guggenberger, and I'm delighted to see so many of you joining in here for a discussion of Brazil's draft AI bill. Our moderator for today will be Artur Pericles, who is a Wikimedia fellow at the Yale Information Society project, and who has written extensively on matters relating to law, technology, and specifically AI. Without any further ado, Art, over to you.
Thank you so much, Nick. And let me welcome everyone to this session. We're incredibly honored to have you here today, and especially honored to have Justice Ricardo Cueva and Professor Laura Mendes with us. Justice Cueva is a justice at the Superior Court of Justice in Brazil. He previously practiced as an attorney in Brazil, serving as state attorney for São Paulo, and as a federal government tax attorney. He was also a member of Brazil's Competition and Antitrust Authority, CADE. Justice Cueva holds an LLB from the University of São Paulo and an LLM from Harvard Law School. He earned his doctorate in law from the University of Frankfurt in Germany. Professor Laura Mendes is a senior visiting researcher at the Goethe-Universität Frankfurt am Main. She's a law professor at the University of Brasilia and at the Brazilian Institute for Development Education Research, IDP. She has a PhD from the Humboldt-Universität zu Berlin, and she also serves as the director for the Center for Internet Law and Society of IDP, is a member of the National Data Protection and Privacy Council, and a co-director of the Portuguese-German Association of Law Professors, DLGV Berlin. We're also happy to be joined by Anupam Chander, faculty member here at Georgetown, and Marcela Mattiuzzo, a visiting fellow with the ISB. Our speakers are respectively, Laura Mendes, Professor Laura Mendes is a rapporteur of the expert committee which drafted the AI draft bill we're about to discuss, and Justice Cueva is the chairman of that same committee. So we're incredibly fortunate to have them join us today, and they will begin with about 15 to 20 minutes, 15 to 20 minute presentation. And after that, Anupam, Marcela, and myself will ask some questions before we head to Q&A. Thank you so much again. The floor is yours.
Thank you. Good afternoon, everyone. Thank you. First of all, I'd like to thank the steering committee and everybody who takes part today in this important debate. Thank you for having us here. As Art said, I've been a justice to the Superior Court of Justice of Brazil. And in addition to that, I'd also have been working closely with the National Council of Justice in special committees dedicated to adapting judicial practices in the whole country to the Data Protection Act of 2018. And in a few other specific committees geared towards the creation of standards for the use of AI in the judiciary. That's why probably I was invited last April to chair this committee in the Senate, which after 8 months could prepare this text, which was brought to the attention of the President of the Senate last December. As to the background of this draft bill, we have to say the House of Representatives of Brazil has had for a few years a parliamentary front composed of maybe 10 or 15 representatives devoted to the promotion of AI regulation. Several proposals had been approved, and at the end of 2021, there's a specific proposal, number 20, which was approved. And that's what triggered the Senate response, right? The creation of the committee composed of 18 legal experts and professors and scholars. Everybody was more or less involved with technology, data protection, AI. Why only legal scholars? That was the first question that some people asked. Why only legal scholars and not technicians and computer technicians, because it's a tradition in the Senate. Simultaneously, the president of the Senate of our country created 2 other committees dedicated to drafting new legislation towards different issues, fiscal issues and impeachment. And we were the third of these committees of legal experts studying a specific subject matter. Professor Laura was the rapporteur. She had been also working she's been working intensely with the data protection. She was one of the drafters of the Data Protection Act in Brazil. She was also a rapporteur in a special committee dedicated to the Data Protection Act in criminal matters, which is still under appreciation in our Congress. And in total, we had originally 4 months, but this period was extended to a total of 8 months. And during this time, we had 4 full days of public hearings. We heard around 60 experts of all walks of life, technicians. We had an international seminar with around 24 experts in the world. We received more than 100 written contributions from companies, civil society, the public at large. Everything is in this site mentioned here, right? So there's a huge source of information, and the input of all this work has been somehow translated in the final text we presented in this last December. We have to say the draft bill approved by the House of Representatives, the most important of them, the one with number 20, incorporated most of the legal principles and guidelines regarding AI that have been discussed in international contexts, like the European Union draft legislation, the OECD guidelines, and the White House Bill of Rights. But it didn't go further. Sectoral regulation would be enough to fill the gaps and provide for effective rules. Our committee instead took most of the suggestions we got very seriously and the contributions we received, and concluded that it would be sensible to regulate AI generally. A comprehensive legislation would be desirable, especially in a country like Brazil, with huge inequality and huge structural racism, which increased the chances of having all sorts of bias. Principles alone were not sufficient to guide providers and operators, and we would definitely need more actionable norms and rules that should be actually enforceable. We understand clearly that, of course, there are specific issues that call for context-specific regulation. For example, the regulation of autonomous vehicles certainly poses different questions that the regulation of facial recognition or medical diagnosis. But we came to the conclusion in a similar way that presented in the European proposals, still in debate, that the pervasiveness and the immediate dangers brought by the indiscriminate use of AI tools call for a comprehensive approach. We, like the White House AI Bill of Rights, we rely heavily upon principles and guidelines which should govern the use of AI tools. Like the European Act, we rely on the idea that the risks posed by AI vary enormously and should be classified in order to apply a set of rules and requirements as to the governance and co-regulation or self-regulation that are fully compatible with the dangers brought about. In addition to that, we have according to our tradition, which was defined in the Consumer Law and the Data Protection Act, we considered important, of the utmost importance, to create a rights-based approach, defining a list of rights which could be enforced and could provide a way of private enforcement which would complement the enforcement of the agency that we hope in the future will be in charge of enforcing the general norms and rules applicable to AI, tools in general, in cooperation, of course, with the specific sectoral regulation, which should be and is being enacted by the specific agencies that we have in charge of different fields. And I think this is basically the biggest difference we have from the American approach is, of course, it's a more interventionist approach. We would have the executive to define an agency, already existing agency, to enforce these rules. Maybe it could be like in France or Holland, the Data Protection Central Authority, or Brazil. It's still in beginning to work, but it could be in the future the authority charge of these matters. We also think we have many other provisions, and we most of them have to do with the governance of AI systems, right? According to the classification of risks, high risk tools of AI should have a more comprehensive codes of conduct and duties to report to the authority, and should be subject to a previous analysis of the an impact assessment of the dangers posed by that specific AI tool. And for example, I don't know if you read that, it was widely circulated in Brazil today, the news that in Colombia, a judge already used ChatGPT to create a decision regarding children or something. And this sort of use, of course, would be considered high risk for us. It should be subject to specific requirements, specific duties of care, specific criteria as to the safety of its use. And it would also imply, being classified as high risk, that specific tool would have to adhere to a standard of civil liability different from a non-high risk tool. Fundamentally, that's the whole idea of our discussion, which also comprises, of course, our text comprises some monetary sanctions. I mean, the central authority in charge of AI would be able to control the adherence to the standards and norms and rules and apply sanctions for non-conformity with these rules. And we hope now that the president of the Senate was re-elected 2 days ago, that he and his fellow senators will be interested in pursuing this work the committee produced and bring it to the national debate in order to advance on this discussion, which we in the committee considered of the utmost importance to the advancement of a legal framework for AI in Brazil. Thank you for your patience.
Thank you so much, Justice Cueva. I would like to thank Georgetown and Yale for the invitation for joining the AI Governance Virtual Symposium. It is a great opportunity to discuss Brazil's artificial intelligence draft bill and to exchange ideas on AI regulation. I will detail a little bit more the proposal that Justice Cueva has already presented. Several studies have demonstrated that risks of AI systems, such as their opacity, complexity, dependent on a large volume of data, and discriminatory potential. Proper regulation is therefore an important vector to allow the development and application of safe and trustworthy AI systems in compliance with the Brazilian legal framework and constitutional freedoms. The issue is challenging in Brazil and worldwide. It is complex, horizontal, multidisciplinary, and involves unintended consequences of the use of technology in diverse social contexts. After analyzing all the inputs that we received, as well as examining in depth different topics, as we divided the members of the committee in 5 specialized working groups, the committee decided to adopt, as Justice Cueva already presented, a comprehensive approach of the law. This is due to several reasons. For instance, consistency and continuity in the Brazilian tradition on regulating technology. We are used with these comprehensive laws, such as the Brazilian Civil Rights Frameworks for the Internet, the Consumer Protection Code, and the Data Protection Act. There are other reasons as well, such as the limitations of the Data Protection Act, since training data isn't always personal data, the idea that we have and that we should cover the whole life cycle of AI, not only the decision-making process, but also the creation of the models and the data training, and the idea that a comprehensive regulation with a certain central coordination seems to be the best way to achieve the goal of harmonized standards and enforcing rights regarding the impacts of AI in specific sectors. So the bill that the committee has proposed has 5 main axes. Principles, the guarantee of a list of rights to people affected by AI systems, the categorization of the level of risks of AI systems, the governance measures and obligations to some providers and operators, and an enforcement structure with liability rules. Firstly, I would like to highlight our concept, the concept of AI that is provided by the bill. An artificial intelligence system is defined as follows: a computational system with different degrees of autonomy, designed to infer how to achieve a given set of goals through approaches based on machine learning or logic and knowledge representation via initial data from machines or humans with the goal of producing predictions, recommendations, or decisions that can influence the virtual or real environment. The definition was inspired by several documents, including the OECD recommendations, the AI Act bill, and the inputs that we received through the public consultation. The previous concept of AI established in the approved bill 21 from the year 2020 has received a lot of criticism since it excluded approaches based on logic and knowledge representation. That is why we propose a broader concept of AI, but which we think that has clear boundaries and covers the main risks and impacts on fundamental rights caused by AI systems. Other important concepts are the AI agents that includes providers and operators. Providers are public or private natural or legal persons that develops an artificial intelligence system directly or by request, aiming to offer it in the market or to deploy it under its own name or brand. And the operators are the public or private natural or legal person that deploys or uses under its name or benefits an artificial intelligence system, excepting systems employed in the scope of non-professional personal activities. These are also called users of the system in some other norms. As for the first X, the bill established principles which are the good faith and other 12 principles. I think we could translate good faith as actually as a fairness principle. I think that would be the best translation. Which are the 12 principles? I just wrote some of them: non-discrimination, transparency and explicability, reliability of artificial intelligence systems, due process and contestability, human participation in the AI cycle and effective human supervision, accountability and attribution of responsibility to a natural or legal person, prevention and mitigation of systemic risks, non-maleficence and proportionality. The draft foresees, as Justice Cueva has already presented, many rights as well, and this is, I think, one of the main points and aspects that differentiates our proposal from the AI Act as well, and from the I think from the blueprint, the US blueprint as well. There are some rights that are stipulated, and these are the right to receive prior information regarding interactions with AI systems, right to explanation, right to challenge decisions that produce legal effects or significantly impact the interests of the affected party, right to human determination and participation in AI decisions, taking into account the context and the state of the art of technological development, right to non-discrimination, and right to privacy and personal data protection. All of these basic rights aim to increase citizens' trust in AI systems, in addition to implementing at the legal level the constitutional principles of transparency, due legal process, self-determination, and equity. The risk categorization, which makes up the second act of the proposal, operates with two categories that receive differentiated treatment throughout the text: the AI systems classified as excessive risks and those classified as high risk. It is up to the system provider, prior to placing it on the market, to perform a preliminary assessment to classify the degree of risk. High-risk systems include systems applied in areas such as operation of critical infrastructure, education, recruiting, screening, filtering, and candidate assessments, private and public services that are considered essential, credit assessment, administration of justice, health, and criminal investigation, among other services. The third act of the bill is composed of governance measures, which constitute a set of due diligence and internal processes to be adopted by the agents that provide or operate AI systems, such as the adoption of transparency and data management measures. High-risk systems require, for their implementation, the observation of specific governance measures in addition to those that already apply to all systems. Among these measures, I highlight the algorithmic impact assessment, documentation, the use of tools to automatically record system operation, the performance of tests to assess appropriate levels of reliability, data management measures to mitigate and prevent discriminatory biases, and the adoption of technical measures to enable the explainability of the results of AI systems. Considering the contributions received by the committee, it has become clear. Just one moment. Considering this contribution that we received by the committee, it has become clear, as Justice Cueva has already explained as well, that a centralized governance structure is necessary in Brazil to guarantee the rights of those affected in a harmonized manner and to provide the legal certainty for law enforcement. So the proposal calls for the government to entitle a competent body to enforce the act and to coordinate and cooperate with sectorial agencies. The proposed regulation is not therefore a legal transplant of foreign norms to Brazil, a country with its own political, economic, and social circumstances, as several specialists warned throughout the international seminar held by the committee. Considering the Brazilian reality, which is permeated by structural inequalities and racism, the project adopts the concept of direct and indirect discrimination, incorporating the definitions of the Inter-American Conventions against Racism, and enacted in the country, in Brazil, in 2022. The measures to combat discrimination in the proposal are plentiful: the right to information and explanation, the right to challenge automated decisions, the establishment of a right to correct discriminatory biases, and the requirement of a consistent and effective algorithmic impact assessment for high-risk systems. As can be seen, the proposal presented to the Federal Senate by the Juris Committee assumes that safe and trustworthy artificial intelligence systems can be implemented by guaranteeing rights and structuring a system of governance and forecasting obligations according to the respective risks generated. As AI applications are continuously being introduced in diverse areas and with varying degrees of implications, it is necessary to consolidate a human rights-oriented regulation and develop a regulatory framework which should combine hard law and soft law instruments, concrete rules and general principles, ex ante and ex post instruments, as well as regulatory approaches capable of ensuring and promoting innovation while respecting the diversity of AI applications and risks. The bill sought to reconcile a risk-based approach with a rights-based approach, using governance instruments that reward the good faith of economic agents who act diligently. We expect that the draft bill will be soon submitted to the formal legislative process and improved in an open and democratic procedure. I am looking forward to the debate. Thank you very much.
Thank you so much, Justice Cueva and Professor Laura. Kicking off here with our questions from the panel, there's a lot to be discussed on this topic, so we could pretty much stay here all day asking you questions. But I'll try to kick off with two that, to my mind, are particularly interesting, speaking in an international context in which people are usually, as you already mentioned, used to the European proposal of the AI Act, or with the blueprint that's in the US. What we have here that I think is particularly different and interesting is a specific set of rights that's very well defined to the affected individuals, right? So individuals that are affected by AI systems have specific rights. And I think that is interesting, and I would really want to get your opinion on how that connects with the risk-based approach that you're also proposing in the draft, right? Because the idea is that different AI systems offer different kinds of risk, therefore they should have different regulatory burdens. But at the same time, we have individual rights that apply across the board. So how do we balance that, right? And how do we make it work? And also adding to that question, jumping on the point that Justice Cueva brought up, how do you think that will interplay with the agency that comes to enforce this rule, right? Because what we have in the draft is we do not have the creation of a new agency, a new authority. We also don't have a specific definition of which of the existing authorities will be in charge. But we do have an idea that an administrative authority in the executive branch should be responsible for enforcement at the administrative level. So if you could offer some thoughts into how do you think that will, and also maybe if you have an opinion about like who should the authority be, I think that would be very interesting to hear. So thank you.
Thank you so much, Marcela. Before I hand it over back to our guest, we have 20 minutes left, and I want to save some time for questions from the audience. So let's just be mindful of that as we head into this section of the talk. Thank you so much. The floor is yours again, Professor Mendes, Justice Cueva.
Okay. So I think I'll begin. Thank you so much, Marcela, for your interesting question. That is a very good question indeed, and we have discussed it a lot in the committee. The rights established in the bill follow also a proportionality scale. The draft foresees, in addition to setting cross-cutting rights for any and all contexts where there is an interaction between the person and the AI system, for example, rights of information and transparency, the right to contest and human intervention when the AI system produces relevant legal effects. In this way, the regulatory obligations differ according to the potential risks of the context in which the technology is applied. Thus, certain general and specific governance measures were established symmetrically to the rights for, respectively, artificial intelligence systems with any degree of risk, as long as the system has any impact on a person. So I would say that we connect this considering, and that is our premise, is that as long as the system impacts a person, some basic rights must be guaranteed, yes? But when you have, I would say, a more intense impact on this person, then you have other rights. And in this sense, we have a scale of rights and a scale of government measures.
Yeah, I think the two approaches are complementary. The idea of a risk-based regulatory system and a right-based regulatory system is not contradictory. I think the allowing people to claim, to go to court individually or collectively to claim their rights is perhaps the most efficient way of ensuring these rights are actually observed. I mean, there should, because I mean, our regulatory framework for both data protection and AI. Well, data protection now should be the maybe the ideal candidate to assume this role, right? But it's still a very small agency with a very tiny human and financial resources. So in the beginning, in the next few years, if this whole idea goes ahead, we should have in place a system of rights ready to use all the tools at the disposal of people, like especially the judiciary, which has been in Brazil very flexible to deal with very complex technical questions from all sorts of things. Data protection, health, technical issues, the regulation of new technologies. We've been working with some issues ahead of the legislation. So I think it would be a way of making this whole idea of assuring some rights more effective.
Wonderful. Anupam, sorry, Marcela, do you have any additional questions before we hand it over to Anupam?
No, let's hand it over to Anupam, and then we can come back later.
Great, thank you. And one more thing before I hand it over to Anupam. To everyone who's watching us, please have your questions ready for when we open it up for Q&A. You can send them along as we are hearing from Anupam, but please have them ready. We'll open it up for Q&A. Anupam, floor is yours.
Well, thank you, first of all, to Justice Cueva and Professor Mendes for a terrific draft. I reviewed an earlier draft, and I thought this is such a huge kind of advance over the earlier draft. So congratulations on a very sophisticated piece of proposed legislation. I wanted to come to one of the central questions in these debates, which is the role of the, as you described it, the provider versus the role of the operator. And you use the term AI agent to refer to both, which is an interest. So these are really important fundamental questions that are going to be, at the heart of all these debates across the world. And so I wanted to come back to the Chat GPT example that Justice Cueva offered in his opening remarks. The Colombian judge uses Chat GPT, which is, of course, a tool offered by OpenAI, a company from based in the United States, and uses it in a way that perhaps, let's imagine, is harmful or illegal, etc. What do we do with imposing liability in that context? How do we apportion liability? What is OpenAI's responsibility here versus the Colombian justice system or the Colombian judge? So I have 1,000 questions, but I thought I'd just open it with that one. It's a fantastic, and I know this is a hard question, so I don't mean to, seek a definitive answer to that question, but I just wanted to see, how does the bill start addressing that kind of issue?
Very interesting question, right? And there are no easy answers to this kind of questions, because the whole idea of having agents of AI is not something that could be easily apprehended, because, of course, there's a very complex production chain of tools, right? AI, sometimes it's not easy to define who is who did what, who made what kind of piece of that final tool that is sold and used. Of course, in this specific case, the judge, in this first decision, is subject to an appeal and so forth. The liability of judges is subject to specific rules. There's a lot of complication, but it's theoretically, being a high-risk application of AI, it should be. It is already infringed. It would infringe upon some kind of rule, would be subject to a sanction, right? One of the agents would theoretically be liable. But who? That's a good question.
I would like to jump in as well. That's a very interesting question. It's difficult already to there are so many challenges to regulate AI in general, and when we think about or on open AI, I think, Anupam, that we have even more challenges. We indeed we propose some rules and norms regarding general applications, and the idea is that the provider shall, from an open AI system, shall make also a risk assessment or understand to which goals or objectives this open AI system or this AI system could be used. And in this sense, I think that the liability would be, I'm not talking about ChatGPT, but I'm talking ChatGPT, but I'm talking about this question on the provider of an open AI system and of the user of this open AI system. So I think that there should be some rules or some limitations from if the provider wants to limitate his own liability, and it could limit it in the sense that he limits the uses or maybe not recommends the use in high risk social context. Yeah. But I think if the user or the operator, as we call it in the bill, in the draft bill, uses in a context that it wasn't recommended, then it would, the liability would, I would say, he would be responsible for this use. So I think that's a little bit the idea. It's not so easy, but we have proposed some norms regarding this challenging and interesting issue.
Wonderful. Anupam, any follow-ups?
No, I see that we have a lot of questions teed up. I have a ton of follow-ups, but I'll cede the floor.
Thank you. So I'll exercise moderator's privilege for just 1 second. After all, I did wear a jacket. So here are some questions. I think one thing that wasn't initially obvious to me as I was preparing for the panel, it became clearer, is that although the act is the Artificial Intelligence Act, the definition of artificial intelligence would, it seems to me, encompass any form of, it says literally encompasses any form of logic representation. So it would encompass not just machine learning, but any form of algorithm that it's even prefixed, that has prefix scores. So if you have your very traditional mechanism where you assign credit limits on the basis of scores for people who hold standard kind of positions or have certain kinds of occupations, etc., that would still be covered by the AI Act as I read it right now. But that's a question I have for you. So it seems that it goes beyond artificial intelligence and it's about algorithms in general. My second question, I think this is, so coming from a role in civil society myself, I think that the regulatory model is, and I think this is a good thing, it relies a lot on participation from civil society, from non-governmental actors, not just industry actors. But I'm thinking we don't have Max Schrems in Brazil, but it's not just that. We don't have organizations with the kind of resources that organizations in Europe and in the United States have. So in the United States, we have a markup. We have a number of universities doing auditing, like say adversarial auditing of systems. And we don't have those in Brazil. And I was wondering if you see this as a challenge. Should the bill be accompanied by appropriations so that we can have more research and we can have more investigation into those by civil society or the press? Final question. This might be quicker. So the right to challenge automated decisions is not just about decisions that have legal effects, as the Act has it, but also about decisions that significantly impact individuals' interests. You think that would also apply to content moderation decisions about ranking and de-amplification? I'll stop there and start grouping the questions from the audience. And feel free to skip over any questions you don't think are relevant.
We had many choices, right, to define the scope of the work. It was not predefined to us. The Senate, the president of the Senate did not define a clear scope of the work, but some ideas, some primary ideas would be just to polish off the drafts presented by the House of Representatives, principles, guidelines, very weak or non-existent enforcement, and we would change the civil liability rules and not much. And on the other hand, some people would come up with ideas like defining very, very precise rules of procurement of AI systems by the government, or creating fiscal incentives to all sorts of AI. And we came to a middle ground with the committee adjourned and concluded that we should not create very Byzantine rules as to fiscal incentives and procurement and so forth. Stay in the middle ground between the AI bill in the White House AI bill, the blueprint you have in the US, and the European proposal, which is intervention, regulation, but not that much. I don't know if Laura has something else.
I'm sorry, just that I was muted. Yes, I just like to add on this the concept of AI and what Artur asked us about the limits and the idea of this concept. I think we discussed this a lot, and the main points, or I think our main goal was to firstly cover the impacts, all the relevant impacts that on people, and in this sense, I think we needed to look not just to machine learning, but also to other kinds of sorting and selections and decision-making processes. So I think that was the first one, the first thing. And I agree with Suresh that he was in this symposium as well. And the idea that we have that the law and the bill should address the impact, it was surely one of the paths that we have chosen. And I think that the second one, and I have briefly talked about it, is that we had to have like a concept broad enough that covers not only decision-making process, but the training data as well, the modeling. So this complex process of decisions, they are based on many other processes that comes firstly. So the idea is that we have to be able to cover the whole process in order to address the impact. So that we know that it's not very easy to come up with a concept, but that was looking to the impacts on the persons, and the idea that we have to cover this whole process, not just decision making, but also this modeling and training data. That this, I think, moved us, and that was why we decided for this concept of AI.
Thank you so much. Professor Mendes, Justice Cueva, can we keep you for another 10 minutes? Is that okay? Yeah. We do have a number of questions from the audience. Okay, so we have a number of questions on generative AI. There's one specific question which I think this is something you might want to touch on. which is about intellectual property rights. And I know that the bill deals with this. So the question is how, with the emergence of language models and generative AI systems, training data pose intellectual property rights infringement concerns. Any thought on how to tackle this? And maybe this is also an opportunity for you to say something about data mining. The following question is about, maybe this is something you've answered already, how you see the Brazilian approach in a global context. But if there's anything you want to add there. I think we have two other discussions about ChatGPT. So the first one is about ChatGPT being prompted to make decisions about children as a high risk. And would this require providers who generally make generally capable system available to users comply if they are high risk? So this is an interesting question, I think, about maybe something like AI as a service. So you provide a general AI system, and users might use it for their own ends, and who bears liability, I think, might be a question here. We had a different question about about ChatGPT. But I want to, this is a question asking you to expand on how helpful were the OECD, UNESCO, and other initiatives and other proposals or regulatory models in your draft. So maybe we'll stop there with this first round, and I'll come back to you if we have some extra time.
We actually did take into account OECD and UNESCO inputs, right? We actually not only read and studied documents they produced, but we spoke with people in charge of these matters there. And of course, it's always important to have a dialogue. I think this is an ongoing project, right? This first draft is just an idea produced by this tremendous collective work, right, of collecting all this information, opinions, and expert assessments, and then arranging this in this committee, presenting it to the Senate. But this is just the beginning, right? And as to the copyright issues, I mean, they are definitely tough questions to find, right? Of course, we preserve in the draft industrial and trade secrets, but this is one of the toughest questions in generative AI: how to protect copyright, how to protect some trade secrets and industrial secrets and the intellectual property without blocking the generative AI, right? It's not clear cut for us. I think we reached a formula which seems reasonable, some transparency towards what the intended purpose of the use is, some risk mitigation, and some participation of different actors in order to give some transparency as to which content is used in that kind of application. But this is not a final answer, it's just the beginning. This is a very difficult task to preserve intellectual property and not preventing the development of these new tools.
Yes, and I'll catch on this point regarding copyrights law. I think copyrights, it's quite challenging, as Justice Cueva said, because on the one hand, we have to preserve and we have to guarantee data quality, and that the data must be representative. And in order to be like that, providers has to have access to many data. a huge databases. And this is interesting because on the one hand, it is we need the access to data in order to have this quality, data quality, and to also to mitigate discrimination risks in some context. But on the other hand, we know that it's quite difficult to understand and to mitigate violation of copyrights. So and this is a good question as well, because I think that's quite different from our proposal, because we had to address this issue in this proposal, since it is not clear if data mining violates copyrights or not in Brazil. So we decided to tackle this problem and to propose Article 42, exactly, which establishes that the activity of data mining by research organizations and institutions, journalism, and by museums, archives, and libraries, as well as by other players in specific situations, does not violate copyrights as long as it is not intended for expressive purposes and complies with requirements provided for international conventions to which Brazil is party. So we tried to tackle this problem. We think we couldn't, it couldn't be left to other acts to solve this problem, because it's really linked to the problem that we want to tackle, that data quality and non-discriminations and etc. But we know that it's quite challenging. So I would say that I would just want to present our proposal and our how we try to tackle this problem, but we know that it's quite a challenging topic.
Yeah, this was one of the challenging topics, right? We actually look to keep an open dialogue with the sector involved with the protection of copyright and intellectual property, because we know how important it is for this area, right, to have their rights protected.
Wonderful, thank you. And I just want to give a shout out to Professor Mariana Valente at University of St. Gallen, who's done important work on the right to research. All right, we have two questions about the regulatory authority. So the draft refers to the competent authority, and there's a technical constitutional question as to why the draft can't itself create the authority itself. But I think our audience wants you to speak a bit on how you see the authority. Which format should it take? Should this be a new agency? Do you have any views on that, or is this something you would defer to the executive?
Yeah, we decided to defer to the executive because somehow we were vaccinated against a flaw in the Data Protection Act, right? I think Laura took part in the whole process, the whole gestation of the Data Protection Act, and she saw how the creation of the authority in the act was vetoed in the end, right? And then it had to be created as an appendix to the executive, and only recently it gained autonomy, and so we decided to defer to the executive to define which agency would be in charge of this matter.
Wonderful.
Yeah, Artur, yes, and in this point, in this subject, it was very interesting because in the hearings, there were many representatives of NGOs and of the government, and as well of the private sector, and I would say that there was almost a consensus regarding the necessity to have like a coordination and a central governance structure. This is interesting because and in our view and in my view, I would say that we know that the sectorial approach is important as well, and the sectorial agencies will play an important role, but without a coordination, without a governance structure that coordinates everything, nothing could happen. So the idea is that we should rely on this coordination. So I would say that this agency should coordinate much more than implement. But it has to have this responsibility to coordinate and to be in a constant dialogue with the sectorial agencies. So it would be a quite complex framework, but we think it could work in the Brazilian context.
Wonderful. I think that's all the time we can keep you. I want to thank everyone for being here. This was wonderful. Thank you again. Thank you, Professor Mendes, Justice Cueva, Anupam, Marcela. I'll hand it over to Executive Director Natalie Roisman, who is the Executive Director here at the Georgetown Institute for Technology, Law, and Policy. Thank you so much.
Thanks so much, Art. Thank you to our distinguished speakers for joining us today, to our interviewers and moderator for facilitating this very important discussion, and to the Wikimedia Initiative at the Yale Information Society Partnership for this continuing partnership. As many of you know, our AI governance series launched during the pandemic. To date, it's been entirely virtual, and we will continue to have virtual events to ensure that our conversations can be global in nature. However, we're delighted to announce the first in-person event in the AI governance series coming up on Friday, March 3rd at 1:30 p.m. on the Georgetown Law Campus. We will welcome Senator Ron Wyden for remarks and a conversation with Chinmay Arun and Anupam Chander. Representative Yvette Clark will share remarks by video, and we'll then have a panel discussion featuring Nicholas Guggenberger, Dennis Hirsch, Mehtab Khan, Paul Ohm, and Kyoko Yoshinaga. Please stay tuned for registration info on this and future events. We hope to see you there. Thanks again, everyone, and have a wonderful weekend.